Ladies and gentlemen, I want to welcome you to the House Judiciary Committee. We're glad to have each and every one of you here with us today. There's a few people I'd like to introduce. The first is Gabe Robbins. Gabe is Ben's son. He is the first 3-year-old we've ever had page in the Alabama House, and we are certainly glad to have him with us. He is back here now eating a lollipop, so he may be light years ahead of the rest of us in this room. I also want to introduce to you Justice Sarah Stewart. Justice Stewart, would you stand up? Justice Stewart is on the Alabama Supreme Court, and she is the Republican nominee for Chief Justice. So we are certainly glad to have her with us. And we have retired Judge Lane Floyd with us from Baldwin. Are you from Baldwin or Mobile? Baldwin County, okay. So we're always glad to have Judge Floyd with us also. He does a lot of work with us in AOC, as does Susie Huffaker, who is here sort of probably guiding them around, but we're glad to have you all with us. Go ahead and call the roll for me.
Hill.
Here.
Wadsworth. England.
Here.
Almond. Bedsole. Brinyard. Chestnut.
Here.
Faulkner. McClammy. Pettis. Robbins. Simpson. Starnes. Stringer. Tillman. We have a quorum.
We got a quorum. Ladies and gentlemen, if you've got it, one of our agendas, I'm going to do this a little out of order. Chairman Garrett has got a meeting he needs to be at. So Chairman Garrett, could we talk about House Bill 348, please?
Yes, sir. Thank you. Thank you for accommodating my request. This is the bill we had a public hearing on last week, which basically would require railroads to decouple the trains at crossings if they know they're going to be down for more than 2 hours, and it's unrelated to a mechanical issue. We had a lot of discussion about that. I'm not well, two things. One, I mentioned to you that I was seeing more frequency of this happening in my district. Then over the weekend, it was a lot of this happening, and I saw some traffic communicate with the railroad, and did see some situations where I think at one point the crew was given the instruction to brake and they didn't, and they admitted in this text that so there was an issue there. And those are internal issues everybody has. I'm not a conspiracy theorist, but I noticed that if you look at my news feed today, yesterday there were action by the city of Birmingham, and all of a sudden they have decided to address this road stopping issue in the Birmingham. They specifically mentioned Trussville and Woodlawn. My point is, I would like to move this bill to keep the awareness and the pressure on them to make to the extent they can plan to avoid these things, to do that. That's my request.
Now, does anyone have any? We did have a public hearing, and does anyone have any questions? Anyone on the committee have any questions for Chairman Garrett? Okay, seeing none, do I have a motion for a favorable report? Thank you. How about a second? Thank you. Got a motion, second for a favorable report. All in favor, please say aye. Any opposed? You got a favorable report, Chairman Garrett. We appreciate it.
Thank you, Mr. Chair, and thank you, committee.
The public hearing on 409 has been withdrawn. Since that's my bill, I'm going to wait. I will do it at the end. And let's see if we can get some of the rest of you folks that don't have to be here out of here. Senator Coleman, are you here on SB 237, or is anybody doing that for her? All right, let's hold that and see where we are. Senator Carney, SB 104.
Thank you, Chairman Hill, and committee members for letting me come. You most recently passed HB 92 on the House floor unanimously. This is a companion bill to that. Representative Stubbs is carrying it here in the House, and I was carrying it through the Senate. What this is an overnaming bill. Only deals with asbestos action and nothing else. Does not prevent anybody from suing. Just requires that they create a nexus between the business that is being brought into this, the defendant, and the actual asbestos action.
And ladies and gentlemen, I believe that we passed this out. I believe we passed this out of the House yesterday. Did we not?
Yes.
Okay, that's what I thought. Are there any questions for Senator Carney? All right, there's a motion for a favorable report. Is there a second? Thank you. All right, any further discussion or any discussion? All in favor say aye. Any opposed? Senator Carney, thank you so much. We
Thank
appreciate
you,
it.
Chairman. Thank you, committee members.
Senator Gavan, you want to talk to us about SB 112, the Alabama Business Nonprofit Entities Code?
Well, thank you. And I almost tried to make the motion for Representative Garrett's bill. I really like that bill. That's needed. This is what I call the Keeping Up with the Delawares Act. Representative Wadsworth and I have been carrying these bills for a while. ALI keeps coming up with changes and comma splices and things like that. And so here we are again, and I'll be glad to attempt to answer any questions. But if you have any real hard ones, I'm going to refer those to Representative Wadsworth.
All right, go ahead, Mr. Robbins.
No, Pettis.
Mr. Pettis, I'm sorry. Didn't see it in it.
Oh.
I'm sorry. Go ahead.
I tried to read this bill last night. Can you explain this in layman's terms? It was
Explain it in layman's terms.
not a lawyer term, layman's.
If anybody can, Senator Gavan can. I'm not sure that's not a question that's a hill too far, but go ahead.
So, well, I am from Safford, Alabama, so I ought to be able to do it. But the bottom line is that as our corporate code, first of all, we've kind of created a hub of the corporate code that spins out in different directions. You know, we have certain things that, whereas it used to be LLCs were all over here and corporations were all over here and whatnot, we're all coming out of sort of with some common terminologies out of this hub. And when you make a change in the hub, then they go, oh, wait a minute, we didn't use the right term down here in corporation, we didn't use the right terms here. So it's got a combination of that together with, well, what did Delaware do to make it easier to do business? And we're constantly trying to keep up because, you know, we don't want to give reasons for our Alabama businesses. And, you know, look, somebody comes to me, they're going to have to ask for a Delaware entity. I'm not going to volunteer it. I'm going to set up an Alabama entity. But especially with some of these bigger law firms and some of the bigger, you know, clients, there are a variety of reasons they want to go to Delaware, and it may be little nuances with the law, and we're trying to take away those reasons so people would qualify there. We want them to be Alabama companies and not Delaware companies that are just simply qualified to do business in Alabama.
I have an amendment. I should have gotten it beforehand, just kind of reading this massive bill, and I don't think it's anything too major, but sorry. It's dealing solely with the statewide trade associations, where on line 4,223, it says that a trade association must have its principal office or headquarters in the city of Montgomery. And I started to think about Shipbuilders Association or NASA or some of those. Seems like they could just have it closer to where they're all located instead of having to have a location in Montgomery. And so I was amending it to say, instead of has its principal office or headquarters in the city of Montgomery, to has its principal office or other headquarters in this state.
I think that's an excellent amendment, and I must confess, I didn't draft this bill. So, and I didn't draft that part on the trade associations. I think that's a great catch.
And one other thing, so this amendment can be split if there's an issue with that, but I noticed in reading that, when I started reading more there, the trade association on lines 4320 through 4330 on page 155, we have where the certificate of, we have all of the rules on when a member can inspect the records that's in code, but then 4320 through 4330 says the incorporation and documents of the trade association can further limit the rights of a member to inspect the records, is the way I read it. And so I just thought it made sense to leave that, just kind of stick with the code and say, here are the rights that members have to records and the rights that the trade association has the authority to limit those records to members, as opposed to letting the incorporation documents further limit that. So it's kind of a clear field for all trade associations.
Okay?
Are you good with those?
I can't have state an objection to that.
Okay. Well, if he's good with it, I'd like to introduce this amendment.
So, hey, have we got that amendment already?
Yeah,
So is it one amendment then? or-
it's one amendment.
One amendment, all right, there's a motion and a second to adopt this amendment, and you consider it friendly, Senator?
I do.
Okay, are there any questions concerning the amendment? Okay, seeing none, all in favor of the amendment, please say aye. Aye. Any opposed? Okay, Senator, it's back to you as amended. Is there anything else that you need to say to us?
I don't think so.
Okay, is there a motion to give, okay, motion for favorable report as amended? Is there a second? Thank you. There's a motion and a second. Favorable report as amended. Any other questions? Seeing none, all in favor, please say aye. Aye. Any opposed? Senator Gavan, thank you.
Thank you very much.
Full report as amended. We appreciate it. Mr. Bedsole, are you going to do Senate Bill 240? Because if I remember it, isn't it exactly the same? You can do it from where you're sitting, or you can go to the front. You take your choice.
Yes, sir, Mr. Chairman. I will remain seated at the moment. Since this is the same bill we just passed off the House floor last Thursday, this is the mental health related bill that defines some definitions for co-occurring diagnosis with substance use disorder and mental health. Clears up some jurisdictions of the probate judge, allows the probate judges to work in concert with circuit, district, and municipal judges to ensure what's in the best interest of the individual that's in the justice system so they can get the mental health treatment that they need. So other than that, I'll be happy to answer questions, but this is the identical bill that we have addressed in this committee as well on the floor of the House.
Okay, is there a second? Second, thank y'all. Are there any questions? Yes, sir, please, Mr. England.
Yeah, just want to tell you how good of a bill this is, and I want to. There's one thing I want to remind folks of. For about a period of 10 years straight, the Department of Mental Health had a different commissioner every year for 10 years. Did you know that? And it just kind of reflects where we are now. There's never been a clear vision, and I'm hoping that some of the progress that we've been making will start to clear that vision and we treat people who are suffering from mental illnesses better here in the state. Thank you.
And I think we all appreciate that, and we appreciate the fact that oftentimes mental illness and substance abuse go hand in hand, and they need to be addressed hand in hand. And while we are talking about it, and I know I've talked to Representative Bedsole about this before, we don't have enough mental health beds in this state. We simply don't have places to put folks that need this kind of help. And so while I think this is a wonderful first start, it doesn't need to be the last start. It needs to be something that we continue to build on. But again, I think we're all supportive of this. It's a good bill, Representative Bedsole, and we appreciate it. All in favor of a favorable report on Senate Bill 240, please say aye. Any opposed? Representative Bedsole, thank you. Okay, Mr. England, how about 299?
Thank you for the recognition. House Bill 299 is a bill that we discussed a couple of weeks ago. It was sent to subcommittee, and members of the subcommittee have an amendment that they put together, and I think Representative Wadsworth, who's the chair of that subcommittee, is prepared to offer it. But what it is it was discussed earlier. It is the compassionate parole bill that just requires the parole board in consideration of those who are in have serious health issues and of advanced age to have some sort of weighted consideration given to those factors. And like I said, I think Representative Wadsworth has an amendment from the Civil Subcommittee that I won't necessarily say it's friendly, but I'll say it's a compromise, and I appreciate their work on it.
All right. Mr. Wadsworth, you got the floor.
Yeah, I do. We had the criminal subcommittee, and we did not have a quorum, and we made some changes to the bill, but they were made without any recommendation to the committee on what we would recommend or not recommend. But it's up to the committee to decide. basically what we've done is originally, if you could come up with parole after 10, if you've served 10 years, and what this does, it makes it where you have to serve 15 years. And also you have to be age 67 or more. And those are throughout the bill. But there's also one other provision. It's deals with the term sex offense. It excluded the sex offense under Section 15-2A-5. We left that in, however, we enlarged it so it's first and second degree. So it covers all the sex offenses that are involved. But essentially, we've made it where 67 is instead of the term geriatric age, we put it 67, and they have to serve at least 15 years of their time before they'd be considered. But it's not, like I said, it's not with a recommendation by the committee. And but that's, I've got the whole, each person has a copy of that amendment before them. Does the chair want me to read the entire amendment, or just?
I think you did. Mr. England, does he need to read it all, or are you happy with the way it's summarized?
It's fine.
Is it, all right, let's do this. Do you move that we adopt this amendment?
We move to adopt it.
All right, is there a second? Thank you. There's a motion and a second to adopt the amendment. Now, as to the amendment, does anyone have a question on the amendment? Seeing none, all in favor of adopting this amendment, say aye. Okay, and any opposed? The amendment is adopted. Okay, Representative England, we're back to you.
If there's no further questions,
Favorable report.
yes, sir.
There's a motion for a favorable report as amended. Is there a second? Thank you. There's a motion and a second for a favorable report, House Bill 299 as amended. Are there any further questions? Seeing none, all in favor of a favorable report as amended, please say aye. Aye. Any opposed? No. Okay, the ayes have it. You got a favorable report as amended.
Thank you, Mr. Chair and members.
All right, Mr. England, you want to talk about 27?
Absolutely. House Bill 27 is a bill that would make, so if someone was sentenced to death by or sentenced to life without parole by a jury, and the judge overrode that sentence, that years ago, that was legal in Alabama. And in 2017, I sponsored a bill along with Senator Brubaker at the time to do three things. Those three things were to remove judicial override, also require a unanimous jury before someone can be sentenced to death, and to also make that application retroactive, so that what that meant was if you were sentenced to death as a result of judicial override, that person would be subject to resentencing and ultimately would face life without parole. Through the legislative process, the unanimity part of that bill and also the retroactive application part of that bill was amended out. So what this bill does or seeks to do is to make that application retroactive, so that I believe 33 individuals that are currently sitting on death row as a result of override could be resentenced. So that's what this bill does.
So this
does in a
bill
nutshell.
strictly deals with the retroactive part of the bill as it got through in what, 2016, 17? Okay. Any questions? Yes, sir, go ahead.
Just ask for a roll call vote.
Okay. Yeah, do you have a question?
I have a question.
Please.
Yes, sir. So I just curious about the practical aspect of how this, is this a request for resentencing, or how would this be corresponded or transmitted from the affected individual to the court?
I would assume that if this were to pass, then there would probably be some sort of hearing, because I think it'd be required because of the resentencing component of it. So there would be a hearing, and the only option that would be available because it's capital would be life without parole. So it would probably be a hearing, probably a motion filed, a hearing, and then that person would be resentenced.
Okay, thank you.
Because the override, what you're doing is undoing the override, aren't you?
Right. And, back in 2017, that was actually a bipartisan bill. We all decided that judicial override was wrong. And we repealed that section. And I think the only right thing to do, in my opinion, is to afford everybody who was sentenced by judicial override the opportunity for resentencing, and that's what this bill does.
Thanks. All right, Ms. Alvin, do you have a question?
So is this then an automatic reversion, if you will, to what the jury recommended?
Essentially, because I would assume that as soon as the ball passed, that there would be motions filed for resentencing, and it would, the only option at that point would be life without parole.
Do we have any of these? How many cases are there?
I think there are 33 left.
Of those 30?
There were 34, but the individual that was put to death by gas earlier this year was judicial override.
Were any of the jury recommendations or decisions of those 33 anything other than life without?
All of them were life without, and the judge overrode those sentences and imposed death.
Nothing less?
No.
Did somebody else have a question or comment?
I just,
Either one. Mr. Clammy, please.
just a quick clarification. As you stated before, this has already passed before. And now, this is the same for this format bill has already passed. But now we just have to, it wasn't grandfathered in, is that correct?
The bill itself was passed. The original version of the bill had those three components that we discussed. But in order to get it passed, there were certain people who wanted to make sure that the jury could remain 10-2, so that the unanimity component was amended out. And then also the retroactivity component was amended out through the process. So what we essentially were left with was just the judicial override component. So not that necessarily it was already passed, but just trying to restore one of those components from the original bill.
And this was a bipartisan effort.
Oh yeah, the Senate sponsor was a Republican, or is a Republican, Dick Brubaker. So I mean, at the time, it passed by a pretty good margin in both houses.
Okay. Thank you.
Mr. Robbins, question or comment?
I just had a quick question, Representative Meany. So right now, so the process was that or let me just ask. So currently a judge has the authority to override a jury, but they don't. And so what you're wanting is for a look back at those decisions made after 2017 by the jury, that a judge can override that jury?
No, it's what essentially is, if you were sentenced to you were charged with capital murder or convicted of capital murder, then you go to the sentencing component. Years ago, a jury could impose life without parole, and a judge could unilaterally override that decision and impose death. We repealed that law, but it wasn't retroactive. So anybody in Alabama history who's still alive that was sentenced to death by judicial override is still on death row, even though the mechanism used to sentence them to death is no longer legal. So what this would do is afford those individuals who are still serving, who are still on life without parole as a result of judicial override, it would allow them to be resentenced to life without parole.
Okay.
Okay. And actually, it's those individuals who are on death row because the judge overrode the life without recommendation, right?
Correct.
Right, I got you. Mr. Starnes?
Yes, sir. I just want to make a comment. I think we have 3 of the cases in Ottawa County in the 19th Circuit. I just want to give 3 examples that we have to consider and remember the impact on the victims and their families. Charles Washington was sentenced to death in 2004 for the Elmore County double murder of 81-year-old Julian McMillan as his 84-year-old wife Florence. Both were found beaten to death in their own home. Washington often worked for the McKinnons and killed the couple after learning they had pocketed $10,000 in real estate deal in South Alabama. Julian and Florence had been married 58 years. Second case, Calvin McMillan was sentenced to death in 2009 for the Elmore County murder of Brian Martin, a young 23-year-old who stopped at the Millbrook Walmart to purchase diapers for his newborn child. McMillan stalked Martin around the store before following him to the parking lot. McMillan wanted to steal Martin's truck, and he shot him in the back of the head, leaving his lifeless body in the parking lot next to his baby's diapers. Last case, James Osgood was sentenced to death in 2014 for the Chilton Brown, 46 years old. In October of 2010, Osgood repeatedly raped, sodomized, and tortured his victim before he slashed her throat over and over until she was nearly decapitated. Osgood fantasized about what it would feel like to kill someone. He picked Brown because he thought no one would miss her. I just want to say, please remember the victims and their families while you vote for this.
Okay, Mr. Faulkner?
I just want to, if I can.
You can, go ahead.
Were any of those folks sentenced by the jury to death?
No.
Or were they, so judicial override? So the jury heard the facts of those cases and decided to impose a life without parole sentence?
Yes, sir. This is, let's see. If these bills were passed, these three inmates on death row for heinous crimes committed in the 19th Circuit would essentially have to be retried for their crimes. To properly sentence a defendant for the crimes arising to the most horrendous circumstances imaginable, the evidence would need to be presented to its entirety.
In the resentencing hearing, it wouldn't be retried. And the thing is, I sympathize with the victims. My family and I have suffered horrible loss through a domestic violence incident where my cousin was murdered and burned in her car. But I also, as an attorney, have a keen respect for the process and procedure of the law. And even when I don't like the result, I have to respect it. If as a state, we determined that judicial override is wrong, and as a way to sentence individuals, giving one person a unilateral ability to impose a death sentence is something that we as a group, bipartisan, decided that we shouldn't do. In each of those circumstances, the jury heard exactly what the circumstances of those incidents were, and they decided that that individual deserved life without parole. There is no difference in the amount of information or the quality of information that the jury considers that the judge does in those situations. So I would figure that the people that know that person best and know those circumstances best decided in that situation that that person was due life without parole. And ultimately, our criminal justice system puts the utmost confidence and respect on the jury's decisions in those cases. What this bill does is put the proper respect and credence to the jury's decisions in those cases. Again, not trying to minimize what the victim's family went through because I've experienced it personally. But at the same time, just another way as we talk about justice and how we mete it out, that if we as a state decide that that sentencing scheme should no longer be used, then we ought to afford that same review to the people that judges override the sentence, and that's all I have.
Mr. Faulkner, did you have something?
I did.
Please.
Mr. England, I respect your efforts, and you've had a lot of bills. In fact, you had one that made it to the floor. And in that bill, dealing with a little bit different issue, but looking at some folks that wouldn't have been charged under the habitual offender law, I believe, had the law not been in place at the time. And you presented quite a few scenarios, leaving out that dealt with different crimes, that it took into account specifics. And you know, the problem here is that this doesn't. This doesn't. It basically says if the judge overrode it for whatever reason, then they get resentenced because we changed the law at some point. But at the time, that was the law, and that was the judge's ability to do that. And judges didn't like doing that. And they were okay when we changed the law. Well, some, I can't speak for all judges, but we talk about a lot of the bills give judicial discretion. They give judges discretion, bills different issues that you file, and let a judge go back to the judge that did the sentence and make a decision. This doesn't do that. This doesn't take it back to the judge. It is automatic and different from what the law was at that time. I'm sure, and Representative Starnes read some cases, and we find this in other areas of the law. It's tough because I'm sure you can pull out a case and argue that, hey, I wish the guy had not been sentenced to this, or this override shouldn't have happened. And you could present a case that would sort of be for this side of the argument. And then you have people presenting a case like Representative Starnes did and showing. And so I understand where you're coming from. I also understand where the victims are coming from, though. And it's a difficult thing to go back and say you were properly sentenced this way and under the law at the time, but because we changed the law, now we're going to go back and change that. And there's cases on the other bills that you have where you can make good cases. I can't remember the bill we had here early in the session on that. It wasn't but where we had the evidence and stuff. But that's my issue with it. I think it's a really tough thing to do, to go back and say that even though and we're not going to talk to the judge, we're not going to find out why the judge did it. What did he see in that trial that wasn't presented? Were there problems in the trial? That the prosecutor missed and didn't do its job, and for whatever reason, the judge was there, right then and there, and he stepped up and said, he or she, and said, no, this needs to be an override. And this doesn't get into any of that. It doesn't let us speak to any of that. And so I think that's the problem that, the concern I have with the bill. I know where you're coming from on it, but I think that's my concern.
Hey, Robert. Sure you can.
If I can respond to that. I'm going to try to choose my words as carefully as possible. But first and foremost, I want to make sure you understand that there isn't any additional information that goes to the judge that doesn't go to the jury in the sentencing phase of a capital punishment case. They're all looking at the same information. So it's not one of those situations where a mistake was made or something like that. They're all judging on the same basis, on the same information, and the reason that's so important is because we don't want to create a reversible error on review. That's the first thing. The second thing is, I have to say, it's really disturbing to me though when we talk about retroactive application, and when we decide to use it. When we just created immunity for doctors to protect them, to do it retroactively for IVF. It's like when we do things out of convenience instead of for justice, it means that we can be malleable when we want to apply these standards. And by the way, it didn't matter for me to give you certain set of circumstances on individuals that were sentenced with habitual offender versus a situation where we're talking about review for somebody who was sentenced under a scheme that no longer exists. They both ended up in the same place. Both of them are, I guess in their own special Chris Either world of dead bills. But the point I'm trying to make here is we had a jury in that situation. And as an attorney in civil cases, and in criminal cases, we put all of our faith in the jury, we put our case out there, and then we have to respect the results, even if we don't agree with them. We, as a legislature, both bipartisan, both sides of the aisle, decided that we shouldn't have been doing override. It wasn't a good practice, and it's reflected in the fact that no other state does it. We were the last state to stop doing it.
Yeah.
So the only point I'm trying to make here is, I'm not trying to retry the case or anything like that. What I'm saying is, if we as a body determined that the sentencing scheme was illegal and it was wrong, then we should afford the people who were sentenced that way the opportunity for review. And I don't know necessarily if you would want to say, under these particular circumstances of murder, this person should get this review and this one person shouldn't, when all the evidence was already adjudged by both the jury and a judge, and a decision was made.
So, look, I'll be very quick, Mr. Chairman, in responding, and just say, I get what you're saying, but we do not know why the judge chose to override. That's the information we don't know sitting here today. And that's the difficult part about this.
Mr. Robbins, did you have something else?
I just had a question. I probably should pull it back. I don't want to wade into this, but from what Representative Faulkner was saying and what Representative England was saying, and I don't know if this is a fool's errand, but would Representative Faulkner feel more comfortable in Representative England if instead of saying shall be resentenced, it said may be resentenced? Would that get, or is that just?
It don't matter. It's not going to matter. Let me tell you why.
Okay.
Let me just talk to you for a second. I have tried a half a dozen of these. The fact of the matter is that capital murder is the only case that I know of that we bifurcate. We bifurcate it into a guilt or innocence phase, and then we have a second, and that is the sentencing phase. Consequently, at the point in time today, if a jury makes a recommendation for life without, then that's it. It cannot be overridden by the judge. If the jury makes a recommendation of death, that is it. It cannot be overridden by the judge. So it is the only case I know of where we bifurcate that system. So when there'd been some comments or questions about could it have been a life sentence or could it have been something other than that? No. In a capital case, when you go to trial, the district attorney must choose whether or not he intends to seek the death penalty. And if he chooses to do so, that limits if the individual is found not guilty, obviously they are gone. But if I'm assuming for a moment that they are found guilty, consequently, at that point in time, the question to the jury is, do you sentence this individual to death or do you sentence them to life without? Those are the two questions. There is not a third question to be asked. Going a little bit further, and the thing, Mr. England, that bothers me about it is this. At the point in time that we did this and we changed the law and we took that discretion away from the judge, and you all know, y'all have sat here with me for years, I'm a pretty big proponent of judicial discretion. That doesn't bother me to make that decision. However, the jury also knew that the judge had judicial discretion. The jury also knew that the judge could override in either direction. So that was a part of that case. But those were at that point in time, that was the only two options, the death penalty or life without. Consequently, if you go back and retroactive the death part of it out, then there is no resentencing. There is simply a changing of the sentence from the death penalty to life without. I mean, that's just, there is no option. There is no door number 3. And again, Mr. England, I hear what you're saying, and I understand that an individual tried today would be subject to a different set of laws, and I've got you. But the individuals that were tried prior to the time we changed the law were subject to those laws that were in effect at that time, and the law that was in effect at that time allowed judicial override, and these judges, in their discretion, overrode. Consequently, it's very difficult for me to second guess or in effect override that which the judge overrode. And I know you disagree, Chris, and I got you, and I've listened and I've talked with you about this, and I had no problem taking that discretion. Again, in the ones I tried, when the jury came back death, that's what they got. When the jury came back life without, I had no problem. I sentenced them to life without. I followed, even though it was not mandatory. I thought it was the right thing to do, but I'm not going to second guess what somebody else did. That's okay.
And again, I mean, I fully respect. I mean, the conversation is, to me, and the issue itself and the conversation is almost just as important to me as the legislation, because I think these are certain issues that need to be talked about. But and you know, full disclosure, you have told me in the past, so this is not a surprise. But again, I just want to say I do appreciate the discussion.
And by the way, in the list of, or the pile of dead England bills, I voted yes on most of them. All right. Is there a motion to give this bill a favorable report? Thank you. And a second. Okay. I think we've had plenty of discussion. You asked for a roll call. Go ahead, Brandy.
Hill.
No.
Wadsworth. No. England.
Yes.
Almond.
No.
Bedsole.
No.
Grinyard. Chestnut.
Yes.
Faulkner.
No.
McClammy. Yes. Pettis.
No.
Robbins.
No.
Simpson. Starnes.
No.
Stringer. Tillman.
Yes.
Noes have it.
I agree with Mr. England. This is a discussion we need to have. We need to have a lot of discussions that deal with our criminal justice system. We need to have a lot of discussions that deal with the way we handle pardons and paroles in this state. There are things that we genuinely need to talk about, and I appreciate this committee being willing, ready, willing, and able to take those up, and it is important. Okay, let me do this for us. Would y'all please go to Senate Bill 237 with me for a moment? I do not see Senator Coleman, and she did not ask me to do this. However, I've read this bill, and I trust that some of the rest of you have likewise. And it looks like to me, you know, when we have children born out of wedlock, one of the things we absolutely can do is retroactive child support. You know, I mean, we've been able to do that for years. What this does is that in the event that the child is born out of wedlock and the paternity is established, what this bill does if you look on lines 85 through 89, it simply orders or directs that child support be going back for within the first year of the birth of the child and up to and 9 months prior to the birth of the child. So what it's doing is it's setting up retroactive child support for children who are born out of wedlock. That's exactly what it's doing. Thank you. Thank you. All right, we got a motion second. Do y'all have? Like I said, I read. Uh-oh. Sir, go ahead.
Judge, as you know, I'm a domestic relations attorney, and what this is doing, I mean, child support, the very nature of child support is to support a child that is here. Mm-hmm. It's for diapers, it's for baby food, it's for clothing, it's for room and board. If you automatically go back 9 months before this baby was even here, now I understand the need to pick up maybe some medical bills or you know, care that she received prior to, but you're setting somebody up for 9 months of arrearage right off the bat that they're going to never, the way it works that interest is running. They'll tack on an extra $100 onto the child support. The interest keeps going. They never will come out of that. I mean, it will just keep going and going and going and going. And it puts the guy in a hole for something maybe he didn't even know about. Maybe he didn't know about until, whatever. Maybe they were unsure about who the father would have been. Maybe she was with several people, whatever. But that, I think, seems inherently unfair to me, to a father. Now, I believe, yes, go back to the date of birth, bingo. But the 9 months prior, I don't see any reason for it.
Tell you what, Mr. Bernier, that is a good point. Since this is not my bill, and she is not here, and I am not interested in defending that, which I have enough trouble defending that which I do, right? However, I am going to carry this bill over. We will give Senator Coleman the opportunity to come here and tell us why it ought to go back. Basically, really what you're saying is 18 months. What she's saying is probably 18, 19 months instead of starting at the birth of the child. Okay, let's carry this over to next week, Brandy, and we'll talk about it. Let me talk to y'all for a second about 409. 409 is a bill that gives a level of immunity to prosecutors. It is prosecutors who are giving advice to law enforcement. Basically, if you'll look on starting at about line 52, let me read it to you because this is the essence of the bill. A prosecuting attorney advising a law enforcement officer or law enforcement agency is defined in 362155 on a matter of criminal procedure, civil procedure, criminal charges, or criminal investigation within the prosecuting attorney's scope of authority is deemed a prosecutorial function, which would give that individual immunity. And I will tell you my rationale behind this bill is I want our law enforcement officers calling our district attorneys and our municipal prosecutors and getting advice from them as to how they should handle a particular situation. And that's exactly the people I want them called. And I want our prosecutors to feel very comfortable in giving that advice at the point in time that they're called. Now, I will answer any questions about this if any of you have. Yeah, sure.
As a prior law enforcement, I think this tool is very valuable. When you're out there on a scene, a lot of times something come up and you need to be able to talk to the district attorney and get his advice on which way to go on a scene or something. I think this is a very good bill, and I support it 100%.
And before we go forward, this is actually a sub. Let me say this. This is I just went over the sub, but I will tell you this. OPS and the trial lawyers have worked on this together, and they worked on it well. And I am very happy with the wordage that they've come up. So I'm going to, the bill that you've got in your packet is sub for 409, and I'm going to offer sub 409. Okay, there's a motion second that we adopt the sub. All in favor of adopting the sub, say aye. Aye. I'm going to now ask that you make a motion for a favorable report for the sub. Are there any questions, Mr. Betso?
Yes, sir. I just want to, so I can respond, because I, like probably other members of the committee, have been contacted about the bill today. What would be the change that was published version out there of 409 and the difference between that and the sub, so I could just boil that down simply?
The sub call for absolute immunity, and that word can be, I think, overly broad. The sub allows them immunity at the point in time that they are acting within their prosecutorial duties. I did not intend for this sub to ever be this bill to ever be a shield for individuals who act in a way that is inappropriate, whether that be misappropriation of money, improperly dealing with pleas. None of that. This is a prosecutor acting in the line and scope of his duties and acting in good faith ought to have this type of protection. Yes, sir, Mr. Robbins.
And I don't district attorneys or government employees already have some form of qualified immunity?
They do.
So,
This if they're acting within the line and scope of their duties, they're acting in good faith, it gets that civil matter dismissed on a motion to dismiss. Because it would be an immunity.
So it would now be, so if I was to bring, so if let's say, whatever the fact pattern is, but you're saying the district attorney acted, you would have to prove that they were acting outside the scope of their duties, and then what that duty was, you'd have to define that and then say, all right, well, you acted outside the scope, so now you are liable and you have no immunity.
And I would see a district attorney that decided to give a police officer advice on his divorce would be outside of the scope of his duty acting as a prosecutor. A district attorney that misappropriated the funds that are given to the district attorneys in order to operate their office, that would be outside of the scope of their duties.
But what if a district attorney in prosecution, let's say they decide that, I'm just thinking of a fact pattern, you can blame my dad. I talked to him about your bill. This is the fact pattern he gave me. He said, so.
Of course, he quit practicing law and went to manufacturing something.
He said, so what if a prosecutor gets divorced and just says, hey, I'm going to just go all in on making my ex-wife's life hell, and I'm going to find charges to bring up against her. I'm going to make life difficult for her or her new husband, and I'm doing my prosecutorial duty. I'm prosecuting someone for some crime. Would they have any recourse? Because that then individuals had to spend large sums of money defending themselves in a matter that was only brought because the district attorney just laser focused on an individual out of spite.
And my answer to that would be they're not acting in good faith. And good faith is an element of any type of immunity. Whether it's stated or not, you have to act in good faith.
But the bill doesn't, could we add something to say if you're acting in good faith? I'm not sure what we'd write there, but.
Well, in the line and scope of their duties and in good faith, if you want to, look, if they are not acting in good faith, then they are not acting in the line and scope of their duties.
Right, I would agree, but then I just thought that you would have to prove that they were not acting within they'd have that immunity to say, well, I was acting within my duty. My duty is to prosecute someone. So even if, and then there could be some charge of something they could find to prosecute someone. So I'm just seeing but then how would you say good faith? Because they could find some charge and they could say, well, it is good faith that I found that you jaywalked and I'm prosecuting for it.
I guess part of this is I really expect our district attorneys to act in a manner that's in keeping with the law, and I expect them to do that which is in the best interest of the public, and I think most of them do. I think we have a public policy issue here that we got to deal with. Go ahead, Tim.
Except maybe in Georgia and New York and those areas. They don't do.
We do better than they do in Georgia or New York and in those areas. I agree. Okay.
I have a question. So what level of immunity is this granting? Because because if they already have discretionary function immunity, right? They have that, right? Like the ex parte Cranman and Butts doctrine where they have to do something outside of the scope of their authority. That's the current state, right? And this would take it to what state?
If they are giving advice to law enforcement that is, and let's say that advice is erroneous, they miss it, they would still have immunity because they are acting within the scope of their line and scope of their duties.
Okay. So, I've had a situation with a DA before who was given extraneous advice that had nothing to do with prosecutions before. Nothing really terrible came of it, but he was, but I think he chilled when someone got in court and said, well, the district attorney told me this, and the judge kind of called him, and I think he kind of slowed down on that then, but that guy would be protected, right? If someone went out and acted.
No, it has to be to law enforcement, and it has to be on a matter of criminal procedure, civil criminal charges, or criminal investigation.
Okay, so
it cannot be, it's not everything that they know in the law. It is within the scope of that which we have elected and hired them to do.
Okay, only to the point to where it's law enforcement, not to anyone else outside of law enforcement.
Anyone else outside of law enforcement? No. I want them in a position where they can talk to sheriffs, deputies, police officers, and do so with a sense of comfort that which they are doing is not going to wind up with them getting sued. But even if they are completely wrong, that's the point of allowing them to give their best. Listen, we're lawyers. A lot of us sitting up here. When you go into a trial, you take a certain position. You move a trial in a certain way. We all know that.
Yeah.
Sometimes we miss that way. Maybe it's not the best way, but I want them free to give advice in their best judgment. Yes, sir, Mr. Brennan. Yes, sir. It would any prosecutor.
I can tell you this happens already. You know, the police officers call the city prosecutors, and all these city prosecutors are private attorneys for the most part. I know we have some full-time in big cities and all that, but the vast majority of our small towns and cities have part-time prosecutors. And so this is somebody that may be a divorce lawyer by day, prosecutor by night. And if they are called by the police and they are giving advice that they truly are trying to do the best they can do, I like the fact that this would protect our prosecutors that are trying to do the best thing, just like Mr. England used to do for the city of Tuscaloosa. If the officer asks him something about an evidentiary matter while they're on a crime scene and they call and they say, you know, we need to know about this or that or whatever, I think they ought to be able to give their answer and not put their, you know, financial life in jeopardy. I like the bill.
I just have one question because he just made me think about something now. So would a defense lawyer be able to call the prosecutor to the witness stand, which would preclude prosecution from his office?
No.
If that occurred?
Wouldn't the prosecutor, as he works for the city, I was a city attorney for 20 years. They were my client. So I would assert that attorney-client privilege in any discussion I had with police or, for that, it's sort of broader, mayor and city council. My city judge, Mr. Bridget, I've had a few with them over the years.
So if it was erroneous information and then the officer's on the stand and he's saying, and he keeps saying, well, I relied on this prosecutor, I mean, you still wouldn't be able to call him, and would you, or it would just stand that if he did the wrong thing, it's on that officer?
I think you probably could for impeachment. Yeah, malicious prosecution or impeachment, perhaps. But those are, yes, I think if a police officer got on the witness stand and absolutely lied, then first thing I think is that the prosecuting attorney has a duty, an absolute duty to correct that. I think that's an ethical duty that I think all lawyers have. You cannot put an individual on the witness stand knowing they're going to lie, and you certainly can't put one on. And if one does so, I think you have a duty to correct that situation. Because obviously ultimately we're after justice, Mr. England.
Oh, just for clarification, do magistrates have that same protection or immunity?
I honestly do not know.
I don't know either, but I know that the conversation between law enforcement and magistrates happens in the same, about charging instruments and what to charge somebody with. So, I guess I'll clear that up later.
I've never thought about that. Yeah. I don't know. Yes,
I didn't think about this until I saw the bill. So, because I always assumed that as long as you were operating in good faith in line and scope of your duties, as a prosecutor that you were protected. I didn't know that you weren't. This was actually a surprise to me.
I think you probably are. I think this gives a level of comfort to prosecutors that perhaps at this moment they do not have. Yes, sir, Mr. Carter.
Yeah, Mr. Chairman, just following up on what Representative Bedsole said, I don't know, some of my constituents are sending me these, some text messages, and I wanted to make sure that it was clear for members of the public that you have filed a substitute bill that has made some changes to this bill, and you've explained those, and so this bill is different from the originally filed bill.
Correct.
Thank you, sir.
And the bill that I hope we vote on here in a minute is the one that we substituted.
Thank you, sir.
All in favor of giving the bill as substituted a favorable report, please say aye. Aye. Any opposed? Good. Okay, one opposed. Representative Hill, you get a favorable report. We have here Allie Grace Broadhead. Are you Miss Broadhead? You are here with Mr. Faulkner, right? And you are a sophomore at Homewood High School. We are very happy to have you with us, and you come back anytime. And you want to be an FBI agent. There's plenty of folks out here in the audience at this point in time that would be willing to talk to you. Seeing no further business to come before, we are adjourned. See y'all next week.